Meeting. This meeting is being recorded.
Well, I guess in any event, while we're waiting, well, Mr. Secretary, could you please call the roll?
Yeah. Commissioner Batimana. Commissioner Boyd.
Here.
Commissioner Guster.
Here.
Commissioner Carp. Commissioner Pecora.
Here.
Commissioner Swanberg.
Here.
And myself. Okay, so we have 2 missing still.
Well, I guess I will call the meeting to order. Has everyone had a chance to review the proposed agenda?
Yes.
Does anyone have any additions or corrections to the proposed agenda?
No.
If not, I would entertain a motion to approve the agenda.
So moved. I second.
Thank you, Mike and Ethelene. Any further discussion on that? If not, all those in favor, please signify by saying aye or raising your hand.
Aye.
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 Any opposed? The agenda is approved. Next, we will take up our case H0035-0008-19. And I take it that, do we have respondents counsel with us?
Yes, Brett Marshall on behalf of the respondents.
I believe you may proceed, Mr. Marshall.
Thank you, Madam Chair, members of the commission. This really is not a difficult case at all. I assume that you've had the opportunity to review the ALJ's decision, and I'll address just a couple things. First of all, Ms. Lacey's exceptions that were filed and why those are really irrelevant, and why we don't need to even consider those exceptions. The exceptions are based upon the ALJ's finding that Mr. Mithelman was not disabled. And the reason that doesn't matter is because she found that there was no discrimination for 2 other independent reasons. The first of those is that Mr. Mithelman, she found that Mr. Mithelman never communicated or told the property managers that he was disabled. The only proof that he presented on that issue was a text message that was sent to the after hours emergency maintenance number, which said something to the effect of, I shouldn't have to suffer. I've been clean for 5 years. And that was it. And then his own testimony. And the ALJ did not find his personal testimony creditable.
Could you tell me what the ALJ is?
The administrative law judge. She's the one that entered the decision.
Okay, thank you.
I'll refer to her as Miss Lockard since that's her name, and hopefully that'll keep it straight. So Miss Lockard specifically said in her decision that she did not believe Mr. Mithelman's testimony on that issue and that she did not find it credible. And as we all know in the law, when we're talking about a review of this type of thing, we usually defer to the credibility determinations of the fact finder. In this case, it was Miss Lockard. So that's number one. So it doesn't matter if he was disabled or not. Miss Lockard did not find that he told the property managers that he was disabled or adequately informed them that he was disabled, which is one of the factors in the law that he has to prove. And keep in mind that on all these factors that were before the, Ms. Lockard, the complainant has the burden of proof. It's his responsibility to prove all the elements of his claim. And he failed to prove that one before before Ms. Lockard. The second one, so even if you get past those first two hurdles, one, that he was disabled, or two, that he told them, there's still a third hurdle that you would have to overcome to find that there was discrimination. And the other element is that his request for an accommodation was necessary for him to use and enjoy the property. And on that issue, the necessity of the accommodation, the ALJ or Ms. Lockard said, it's not necessary. And the reason she said it wasn't necessary is because the basis for his was that there was
I'm on the meeting. What's on your screen?
and pervasive marijuana odor coming from the apartment
I joined about.
building. And Mr. Mithelman testified to that, but the problem is every other witness that testified at that hearing, including the other tenants that were in the same building, all testified that that wasn't true. No one could verify, other than Mr. Mithelman, that there was marijuana smoke in that building. His neighbors said there was no marijuana smoke in the building. The property maintenance manager said there was no marijuana smoke in the building. So the only evidence that Mr. Mithelman presented on that issue was his own testimony. And again, Ms. Lockard put in her ruling that she did not find his testimony credible. And again, on those issues, we defer credibility determinations to the fact finder, again, which in this case is the administrative law judge, Ms. Lockard. So on that basis alone, we don't even need to talk about whether he's actually disabled, whether he told them that he was disabled. When it comes down to the necessity, the element of necessity, he presented no proof. So this case is really about a failure of proof. And as I said at the beginning, it was his burden to prove those elements. And unfortunately, he showed up the hearing with no evidence. And except his own testimony, again, which Ms. Lockard said was not credible. And it's not surprising, given that Mr. Mithelman is a convicted felon with a history of dishonesty, forgery, and theft. At the hearing, he even testified that after this happened, when he was employed at Hy-Vee, he was discharged he wasn't clear on this, but for theft from Hy-Vee. So again, this comes down to credibility. His testimony wasn't credible. He didn't present any evidence, and the ALJ found that there was no discrimination on those bases. So all Ms. Lacey's arguments about whether he was disabled or not is irrelevant. You can swap those aside. All you need to find is, was there marijuana smoke at the building, as he alleged? And you'll see that the record indicates that there was not. And on that basis alone, we would ask you to affirm the administrative law judge's decision and find that there was no discrimination in this case. And I'm happy to take any questions if somebody has a question.
Thank you, Mr. Marshall. I would just interject here. I have learned that Rabbi Karp is now in the meeting where he has been with us since 9:05. So I am going to turn the management of the meeting over to Rabbi Karp at this juncture. Thank you, Rabbi Karp.
First of all, let me apologize for being late. I overslept. What can I say? But I did get to come on into the meeting just as Ms. Swanberg was opening the meeting. And thank you very much, sir, for your testimony. Now, Mr. Mithelman is here. I imagine that you wish to testify as well for the committee, commission. Is that correct, sir? You have to unmute.
Can you hear me now? I'm sorry.
Yeah, okay, we hear you now.
All right. Sorry about that. I'm new to the Zoom platform. First of all, I'd like to address the and say good morning to all the members and thank you for your time for this hearing about this case. You know, excuse me a second here. I'm a little. As with the post-hearing briefs and with the with Ms. Lacey's decision to overturn the ALJ's being that there was not should be overturned. For the following reason: one, to prove that a person is disabled under the ADA, it specifically states that a person is considered disabled if there's following factors that have to be met, and the one that fits this case is the fact that I'm a person former use of substance abuse, and that can be proved by the record. If you look at the my exhibits that I submitted to the commission, that I completed substance abuse treatment with ASAC back in 2014. And that was a successful completion. And every year following after, I have provided evidence that I am in sustained remission and the user. The second issue is it doesn't matter what there was that the ALJ found that there was because in fact there was discrimination. Reported multiple times to the landlord that, hey, there's marijuana going on. I have no reason to make anything up. There's marijuana. It was affecting my health. It affected my job to the point where I had to voluntarily quit one of my jobs because affecting my sleep. I dreaded going, I couldn't sleep because I was afraid that if I were to randomly get drug tested, that, you know, with the presence of marijuana, that I could be, found to provide a dirty UA. And then I was on court supervision out in Peoria, Illinois for a previous case. And if for some reason my probation officer decided he wanted to show up at my house and smell that there's marijuana, there could be grounds for a violation, which would cause me to get in trouble. And also, you know, with this, they had, under the fixing law, they had the sole duty to not just say, okay, well, yeah, Sean, you got to do this, this, and this. They had the responsibility under the law, interactive process, to say, okay, please, and show me this, show me that, and then do a interactive process or open a dialogue to show communication that they actually investigated, which they never did. They just flat out denied the request, said, no, we can't move you, we can't do anything. You're under contract with the current building owner, and there's nothing we can do. So for those reasons, that they can and the commission should overturn the ALJ's decision, find it in favor of the complainant. I want to thank you for your time. Thank you.
Thank you very much, sir. Are there any questions for Mr. Mithelman? Seeing that there are no questions for Mr. Mithelman, I believe it is time for us to go into closed session. Am I missing something, Latrice?
I think I would like to talk about the exceptions that were filed. The hearing officer erroneously disregarded Mr. Mithelman's testimony. There was no indication of why there was a perception that he could not testify to the effects of the failure to accommodate him. HUD has found that that is completely appropriate for the complainant to testify on their own behalf as to their disability and the impact of a failure to accommodate. Mr. Marshall said that it doesn't matter, or said that none of the witnesses were able to verify that there was marijuana smoke in the building, or that they smelled it, but that is not the actual question. The respondent had a duty to engage in the interactive process with Mr. Misselman. So once they were made aware that he has this disability, he's requesting an accommodation, they had a duty to engage in the interactive process, whereas in this case, they just denied the accommodation. He requested that they move him to another building, that they let him out of his lease, and they declined both of those. So to say that they were not made aware of his disability or his need for an accommodation, that's not supported by the record, because it's in the record that they denied the request. So clearly they knew that he was making the request and that there was a reason for the request. So he did tell them that he had a disability, and that was a request for an accommodation. He doesn't have to use any sort of special words under the law. If they are aware of his disability and his need for an accommodation, then the duty triggers for them to engage in that interactive process. The hearing officer's definition of disability is not consistent with the law. There are some disabilities that, or some conditions that on their face, you can tell that they're a disability, and they don't have to go through that kind of two-step analysis, because just by their very nature, they impact a major life activity. Substance use disorder is one of those conditions. So obviously, if you've been diagnosed with substance use disorder, then there are the associated major life activities that come along with that are impacted by that.
I think we lost, did we lose Ms. Lacy? Did we lose Ms. Lacy?
All of a sudden, it said Beth was the host.
I can't hear you, Jeff.
All of a sudden, it said Beth was the host.
Okay,
I don't know why it switched from Latrice to Beth as the host.
but,
Or hostess.
yeah, no.
Yes.
Ms. Lacy is back.
I'm not sure what happened. I just totally disconnected there. Do we know what the last thing was that you heard me say?
You were talking about the fact that the hearing officer misunderstanding or of the definition of disability.
Yeah, so there are some conditions that on their face, they constitute a disability just by their very nature. And that's found within the law. Our ordinance obviously says that the current illegal use of illegal substances does not come within that coverage. So that would mean conversely that someone who's in treatment or someone who is who has substance use disorder relating to their use of legal drugs would be within the coverage. So for those reasons, the exceptions to the hearing officer's decision were submitted.
Okay. Any questions from Ms. Lacy? Now, I believe, was there or was there not a text? If I remember from the last hearing, that needed to be read as we entered into closed session. Latrice, could you answer that, please?
Yes, Jeff, do you have that, the script for them to? Let me have Beth send it over.
I think I do.
Mr. Chair, are we still within the period when we can ask questions?
Yeah, until,
Yeah.
until Jeff actually reads that text,
Okay,
we can
thanks.
ask questions.
Madam Director, can you tell us what the site is for your position that the claimant's disability is a per se disability and he doesn't need to be held to prove any particular impairment that substantially affects a life activity?
She's muted.
Trish, you're muted.
Sorry, I'm working on one screen today. It's a little different. So it's within the exceptions that were filed, but there are various sections within the law that very clearly indicate that substance use disorder is included as a covered disability. I think the most obvious would be that our ordinance clearly says that the current illegal use of or addiction to a controlled substance as defined in Chapter 124 of the Iowa Code is excluded. So that means that the current legal use of or addiction to a drug that could be considered a controlled substance, which could be prescription medication, is a covered disability. That's the same thing with like opioid addiction and those conditions. So that's within the Davenport ordinance, and that's 2.58.030. I think it's on page 4 of the brief that was filed. There's also various sections throughout, like the EEOC, ADA provisions that clearly say the same thing as well. So I don't have all of those sites for you, but it's within the law. It says that very clearly in the municipal ordinance.
But the cases seem to say that something like substance abuse disorder can be a disability, and then it has to impact a major life activity. Is it your position that that's not the case?
No, a disability. So it could be a physical or mental impairment, and it impacts a major life activity. That's the definition of a disability.
Right, but to fit within that definition, doesn't a claimant have to show that their disability impacts a major life activity?
No, that would be the same as if someone was blind. We know that it impacts their ability to see. So you don't have to have them prove that their blindness impacts their ability to see, because on its face, you know that that impacts a major life activity, which is their ability to see. And within our ordinance, it says that the current illegal use of or addiction to a controlled substance does not meet the definition of disability, which would mean that they're not saying a physical or mental impairment, they're saying as a disability. So not the broken down definition of a disability, it's a disability. Does that make sense?
Well, I must admit I'm having trouble with this. It doesn't seem to make sense to me to, in a situation like this, to not require that a claimant show, the limitation in their life.
Right, and I don't think that was the argument made by me in my statement. It was that the definition of disability that was used by the hearing officer is inaccurate. Mr. Mithelman during the hearing did testify as to how it impacted his major life activities. He testified that it impacted his ability to stay in his housing, that's considered within the definition of being able to care for oneself, because you have that access to housing. And HUD has found that in numerous decisions as well. Additionally, he testified that it caused him anxiety. It exacerbated other health conditions. So there was testimony about how it impacted his major life activities. It seems like the hearing officer decided that because he was the one to testify about it, it was not sufficient, as if he had to have a third party testify about it, and that's not what the law requires. But the definition of a disability is a separate issue from how it's impacting his major life activities. So under the definition of disability, it would be you have a physical or mental impairment that impacts a major life activity. And I think your question goes to, you think that it constitutes a physical or mental impairment, so how does it impact a major life activity? But that's not what our ordinance says. Our ordinance very clearly says that current illegal use of or addiction to a controlled substance as defined in Chapter 124 of the Iowa Code does not constitute a disability. So it's not saying it does not constitute a physical or mental impairment. It says it does not constitute a disability. So there are certain conditions that on their face, they are a disability because they impact a major life activity. And within the brief submitted, it goes through how substance use disorder impacts major life activities. So if you have been diagnosed with a substance use disorder, then you have to have some impact. You have to have some impact to a major life activity, and it's not supposed to be this really convoluted, really hard to meet standard. It's supposed to be a standard that's pretty easy to meet, because if people have to jump through hoops just to prove that element, then it's going to exclude a lot of people from the coverage of the ADA and Fair Housing Act. And that's why the law was amended back in 2008.
Well, and if I can ask, Mr. Marshall, you have argued in your submissions that there is not a pro se rule. Can you?
I would also like to clarify, Mr. Marshall did not timely file those, his response to those exceptions, so that's not supposed to be being considered because it wasn't timely filed. It was submitted to the commission because it was filed, but it was not timely filed. It has to be filed within 15 days.
On that issue, I'll just say I couldn't file them within 15 days because there are objections to the exceptions which weren't filed in time. So, one way or the other, whether you want to take it in my submissions or accept my argument today, which you can certainly do, I'm happy to answer any questions that you have regarding that.
Well, Mr. Marshall, I just have the question about this idea of substance abuse disorder being a per se disability, that there's no kind of particularized analysis of how the substance abuse addiction impacts the major life activities of a claimant. Can you explain your position on that?
There is not now, nor has there ever been, a per se disability in the law. If you look at the United States Supreme Court case, the preeminent case on disability, which is Sutton versus the United States Airline case, the United States Supreme Court says it requires, determining whether somebody has a disability, requires an individualized inquiry to determine whether an impairment substantially limits a major life activity. That's the United States Supreme Court, folks. So I'd also like to point out that the cases that Ms. Lacey cites in her exceptions to try to draw out a per se rule don't say that at all. And I've noted that in my objections. They say that substance abuse can be a disability, but you still have to show that there is a major impact to a substantial impact to a major life activity. If you look at the Bear Shield versus John Morrell and Company case, which is the Iowa Supreme Court, again, This is what the U.S. Supreme Court says. The Iowa Supreme Court has said the same thing, that the issue of whether an individual has a disability is a factual question to be decided on a case-by-case basis. And even the cases that was cited by Ms. Lacey in her exceptions regarding the alcoholic, which she says alcoholism is a per se disability. That same case says that alcoholism is not a per se disability. It says that's the Parkstone property owner's case. So that I cited in my exception, which said that an inquiry of whether someone who is an alcoholic or an addict is handicapped within the meaning of the Fair Housing Act is done on a case-by-case basis, because mere status as an alcoholic or addict does not mean one is substantially limited in a major life activity. And we don't deny that it's possible that Mr. Mithelman's prior substance abuse could be a disability. That's not the question. The administrative law judge found that he didn't present enough evidence to show that he was disabled. She didn't believe what he said. It's a credibility determination. And this commission should defer to the ALJ's credibility determinations. You know, it's the same thing with regard to whether Mr. Mithelman told them. Ms. Lacey says, well, he did tell them. Well, no, there's conflicting evidence in the record. Mr. Mithelman says he told them. The property managers said they never told him, or he never told them that he had a disability. There's conflicting evidence that the ALJ said she could not jive together. And so she had to make a credibility determination. And she determined that Mr. Mithelman was not credible.
Are there any other questions to any of the parties?
And I think I'd like to clarify the 29 CFR section 1630, Janelle, to answer your question, it specifically lists out conditions that you don't have to guess whether or not they are a disability, because by their very nature. So contrary to what Mr. Marshall just said, there is a regulation that interprets certain conditions to, on their face, constitute disabilities. And that's found there in that code section.
Do you have that language?
It says it should be easily concluded that the following types of impairments will at minimum substantially limit the major life activities indicated. Deafness substantially limits hearing. Blindness substantially limits seeing. And intellectual disability substantially limits brain function. So it lists quite a number of conditions, and it's saying if you have this condition, by its very nature, it impacts a major life activity. Within the brief filed, it lists the DSM-5 criteria for you to be considered to have substance use disorder, and each of those criteria lists a major life activity. So again, if you've been diagnosed with substance use disorder, it's obvious that you have something that limits a major life activity, because that's how you got diagnosed with that condition. And so it lists out each of those items, and that's within the brief that's filed.
But 29 CFR 1630 doesn't list substance abuse disorder as one of those per se disabilities. Is that correct?
Let me see. No, that one isn't specifically listed. But again, it's listed within the brief how you can be diagnosed with substance use disorder. And so in order to be diagnosed with that, you have to have one of those criteria, and all of those limit a major life activity. So the commission can look to its own ordinance and determine that that is a disability.
Well, and the DSM-5, is that talking about current usage or addiction that is in remission?
This is explained within the brief. So I think that the issue comes from bias relating to substance use disorder, and a misunderstanding of it as a chronic illness. So people don't recover from substance use disorder. They are, for the rest of their lives, in recovery and trying to maintain their sobriety. It's not something where you just magically get over it and then you no longer have to worry about it. And as such, if you, and either way, I think he has a history of substance use disorder. Because it's a chronic disability or chronic illness, then it constitutes a disability in that respect as well. So he meets two different definitions, and it's unclear where the disconnect there was on how that is defined within the law.
But as I read, I mean, substance abuse disorder means a diagnosable substance abuse disorder of sufficient duration to meet diagnostic criteria specified within the most current DSM, which in this case is 5 of mental disorders, published by the American Psychiatric Association, that results in a functional impairment. So I'm sorry, that's where I'm getting hung up on. You seem to be saying that the mere diagnosis of a person having a substance abuse disorder means that that's already been decided.
Yes, because you've been diagnosed with a disability. So it clearly lists out, if you go to page 3, it lists out the criteria, and one of those could be that all of their daily activities revolve around the substance. So that's impacting a major life activity, which is going about your day. Social impairment, so the ability to engage in social interactions and maintain friendships, that's considered a major life activity. Meeting your obligations at work or school or at home, those are considered major life activities. I think that you are getting hung up on a point that the law says you're not supposed to. So you're not supposed to go through this really strenuous evaluation of what constitutes this major life activity. Because, again, if you have to go through so many hoops, no one would meet the definition. And that is why the definition was altered or amended to make sure that people are not being excluded from from being considered as having a disability. And that was the reason that the ADA was amended. Iowa law has always been that kind of broader interpretation that goes in favor of determining that the person has a disability. So it lists out risky use of substance. You're engaging in situations that could be physically hazardous. Again, that's a major life activity. It lists out that these are like neurological functions. So if there is something that you have an addiction to, then it is impacting neurological functioning. And neurological functioning impacts all areas of your major life activities because it's impacting your brain. And that is considered a major life activity. So by its very nature, substance use disorder impacts neurological functioning. So in order for you to be diagnosed with this, that means that you have a condition that has been determined to impact neurological functioning. And if it impacts your neurological functioning, then it's impacting a major life activity. And again, if you go back to our ordinance, it specifically excludes current illegal use of drugs from the definition of disability, which would mean that current legal use of drugs is not excluded from the definition of disability, not not a physical or mental impairment. It's disability.
But, I mean, so one of the cases that you have cited, where the disability was multiple sclerosis, and you say the law recognizes some conditions as disabilities on their face, eliminating the need to engage in the two-step process of determining whether they impact a major life activity. And you cite the Goodpaster case, right?
Okay.
But, I mean, in that case, the plaintiff had to prove a substantial impairment of one or more life activities. And it seems that the same is true of alcoholism. I mean, isn't the Consolidated Freightways case, doesn't that stand for the proposition that alcoholism can constitute a disability if it constitutes an impairment of a major life activity?
No, it specifically lists out this is going to impact a major life activity. If you are experiencing alcoholism, then obviously you cannot stop drinking alcohol. So necessarily it's going to impact these other areas of your life. If you are consistently under the influence, it's going to impact these other activities, major life activities. Just by its very nature. You don't have to guess that if you are consistently under the influence of alcohol, you're going to have an impact in other areas of your life. It's going to impact your ability to drive. It's going to impact your ability to go to work. It's going to impact your ability to interact with your family members and others. These are considered major life activities. And the law explicitly states that you're not supposed to get hung up on the definition of disability and figuring out whether or not it meets a major life activity, because major life activities is basically anything that allows you to go kind of live your life. And HUD has found that your ability to utilize your housing or access housing could constitute a major life activity. And we can see from the record that Mr. Mithelman is alleging that his ability to use and enjoy his apartment was impaired by the presence of marijuana smoke, which impacted a physical or mental impairment. If you want to, even if you wanted to not have a full understanding of major life activity, it definitely constitutes a physical or mental impairment, and the ability to use or enjoy his housing is a major life activity. So either way, he has met that standard under the law because of that information, that testimony that has been provided.
Well, and if I can just make one last, I mean, you cite Goodpaster for the proposition that, in this case, multiple sclerosis would be a per se disability, right?
Yes.
And, you know, in the Goodpaster case, the court said, accordingly, we hold multiple sclerosis can constitute a disability under the Iowa Act if the plaintiff produces evidence that the condition substantially impaired one or more life activities during episodes or flare-ups, even if it did not impair life activities at all when in remission.
Right.
So that doesn't sound like a per se rule to me. It sounds like the plaintiff has to produce evidence that the condition substantially impaired one or more life activities, is all I'm saying.
If you have muscular sclerosis, then how would that not impact your musculoskeletal functioning?
Well, I'm just reading you what the court said in that case.
Right, and the law says that something that impacts your musculoskeletal function is a per se disability. These are the impairments that you can guess limit a major life activity.
But again, the court said in that case, MS can constitute a disability if the plaintiff produces evidence of
right, and that evidence doesn't have to be a written documentation. That can be your testimony that it impacts a major life activity. So the complainant in that case could say, well, it impacts my ability to stand for long periods of time, or sit in a certain type of chair, or work, you know, this many hours in a day. that is evidence that it impacts a major life activity.
All I'm suggesting is that it seems to be evidence that the plaintiff would need to produce. That's all I'm getting at.
I just need to get this on.
And that's not one that's specifically notated within the law as it is in our ordinance, which specifically lists substance use disorder. It specifically states it.
And that it can be a disabling condition.
A disability is what our ordinance says.
Can the members of the commission hear me?
Yes.
Yes. Yes.
I just need to interject here. We're talking a lot about, these DSM criteria and whether alcoholism or multiple sclerosis is of the type meets those criteria. And the fact of the matter is none of this was presented as evidence before the administrative law judge. If Mr. Mifflin wanted to show that he met the criteria under the DSM and that he has a per se disability, he should have put an expert on the stand to testify. Instead, we have Ms. Lacey testifying as if she's an expert on substance abuse and whether or not it's a per se disability. I think it's highly inappropriate. The commission needs to focus on the evidence in the record that was presented before the administrative law judge.
And I would clarify, it was entered into the record that Mr. Mifflin was diagnosed with the substance use disorder.
Is there any further discussion on these matters? Is there any reason why at this point in our deliberations that the commission should not go into a closed session to consider this case? Hearing none, then Jeff, have you received the script?
I did, yeah.
Could you please recite?
So, pursuant to Iowa Code 21.51F, I need to ask for a motion to go into closed session.
So moved.
I second.
Okay, and then I need I believe just a voice vote, yay or nay, for all of us to go into closed session.
All in favor, say aye, raise your hand, please. So
Aye.
Aye.
Michael, are you raising your hand? We can't, yeah, are you saying aye? Yeah, just want to confirm. Michael?
He's driving.
Yeah. Aye, he said aye, okay.
Okay, so all
Any
commissioners,
opposed? Okay.
okay.
Thank you, everybody.
Thank you for your testimonies, both you and Mr. Mifflin.
Thank you.
Okay, so now we go in, yeah. So now we go into closed session.
Okay, at
Okay,
9
join the everybody join all the members of the commission join the breakout room.
And so, Mr. Mifflin and Mr. Marshall, they're in the breakout room. If you wanted to stay on until they come out, I'm not sure how long they'll be in there. I will probably disconnect and leave Beth Badillo here in the open session. But if you wanted to wait until they come out to see what the result is, you can do so. If not, we'll send out something notifying you of that.
Ms. Lacy, can I ask a question?
Uh-huh.
Yeah, so this is my question to you is, so, I'm sorry, you were kind of cutting in and out. So say that I can stay and, you know, kind of listen to what they say, or did you say that you were gonna send something out?
We are in the open session, and they are in the closed session, so they're in a separate room. And when they come out of the closed session, they will have a decision.
Okay,
I'm not sure how long they'll be in closed session though. So if you wanted to wait until they come out, you can. And if you wanted to disconnect, you can do that as well, and we can send out information about what the determination is.
okay.
Beth, the whole group wants to come out of the room.
Okay, are we all getting back?
Oh, we have two of us out.
Yeah.
How about the rest of everybody else?
Yeah, I had to press two things, leave room and then leave breakout session.
Well, Michael can't do that when he's, driving. We got, who's the Beth, are you the host?
Well, she's muted too.
She's muted and she's not answering. Okay. Next step, I'm gonna call Latrice. All right, Latrice, we are not getting out of the breakout room. I'm out, and Jeff's out, and Richard's out, but Janelle and Michael are still caught in the breakout room. Okay, well, I spoke with Beth, and all I see is her picture, and she's muted, and she hasn't responded.
Sorry, can you ask that again?
Yeah, but Michael can't do that because he's driving. Can he be brought out? Can the breakout room be closed? And the people return to the main meeting?
Yeah, hold on, I can do that. Hold on one moment.
Okay, we're still missing Janelle. Okay. We're still missing Janelle.
Break room. Okay, I've left the breakout room.
Oh, okay, I think we're, okay, I'm gonna hang up Latrice. Okay, I think we're all here. 1, 2, 3, 4, 5, 6. Yeah, we're all here. Okay. Now, the text for re-entering the open meeting, Jeff?
Yeah, it just says, when we come back, I guess we're considered a contested case, right? Because there was one no.
Well, yeah, I mean, it came to us for review.
Yeah, I think if we were all in agreement, all we have to do is say we were all in agreement, but in a contested case, it says the vote, if one is reached, must be taken in open session. So I think we have to vote.
Okay, so then, Jeff, as secretary, can you do a roll call vote on this case for us, please? Can you conduct a roll call vote for us?
Yes. Boyd,
Yes,
I think we have to vote, adopt, reject, modify, or demand, or remand the decision of the law judge, of the administrative law judge.
adopt.
Commissioner Gusser,
Reject.
okay. Commissioner Carb,
Adopt.
Commissioner Pecora,
Adopt.
Commissioner Swanberg,
adopt in its entirety.
Okay, and Commissioner Transu, I'm adopting also. So we have 5 adopts and 1 reject.
All right, so by vote of the commission, is there another text that we confirm the vote? Yeah. Jeff, do we have a formula for affirming, for the outcome of the vote?
Other than the, roll call, you mean?
Other than the roll, I mean, is there a required text that has to be read that this, that affirms how the commission voted? Required language.
Just to reconvene in the open session, just when we reconvene in the open session, the motion by you and seconded by me, and then we vote. And that's all she's got here.
All right, then by majority vote of the commissioners, the commission has voted to adopt in its entirety the decision of the administrative law judge.
Okay.
Now, Beth, can you bring up the agenda? See if there's anything beyond this that's on the agenda? that we have?
Yes, just give me a few moments.
Okay. Yeah, it seems that we've lost trees in this meeting.
What are we waiting on?
We're waiting on the agenda. Yeah, Beth is bringing up the agenda, make sure
Oh,
you haven't got any other item like public comment or what have you,
Yeah,
Yeah, I
think
gotcha.
public
agenda
comment-
before we adjourn.
okay.
Public comment adjourn and next meeting.
Okay, well, then, open the floor up for public comment. Any comments from the? It there are no comments from the public, then I will entertain a motion to adjourn.
So moved.
When is our next meeting?
Our next our next meeting, will be on the second Tuesday of the month of April. Our standard meeting time.
Okay.
Our set meeting time. I'm looking for a second to adjourn.
I second.
Okay, all in favor of adjournment, signify by saying aye.
Aye.
Aye. Any noes? Then, as we used to be, as people used to say in elementary school, the ayes above the nose. We stand adjourned.
Okay, Ken.
Bye, all.
Thank you all for your participation and your attendance and for your good work.
Take care, guys. Have a good one.
You take
Bye.
care. Yeah, everyone have a good one.
Two.
Sorry, I was still trying to pull it up there. It was having a problem with my screen sharing for some reason. I don't know if it's because of the host privilege. So I was trying to pull that up. I apologize, but I get that you adjourned.
Yeah, we did it. We did adjourn. We opened the floor for public comment. There were no public comments, and then we moved for adjournment. And it was a unanimous decision.
Okay, I'll stop struggling with Zoom then, trying to pull that up. Thank you. Sorry about that.
Okay. Bye-bye.
Goodbye.